Hello students, welcome to this class. And in this class, we are looking at chapter number 7, which is about the law of treaties. So the purpose for this chapter is for you to understand the rules and principles that govern the creation, interpretation, application, and termination of treaties, ensuring legal clarity, stability, and cooperation between states in the international system. So these are the objectives for this chapter. So treaties and conventions are one of the four sources of international law as spelled out in Article 38, Section 1 of the Statute of the International Court of Justice. So other sources are customary international law, general principles of law practiced across civilized nations, and judicial decisions of international tribunals and ratings of the most highly qualified publicists and scholars. So treaties are governed by customary international law in two senses. Firstly, the rules determining whether or not a treaty has been created have long been part of customary international law and therefore binding on states which follow the said rules. Secondly, treaties may also be considered as laying the foundation for the evolution of customary international law. For instance, a rule that is stipulated in a treaty is initially binding only on states that are parties to the treaty and not on non-state parties. So, the Vienna Convention on the Law of Treaties was adopted in 1969 and came into force in 1980. And it is a treaty that lays down the rules of international law regarding the following: uh, how treaty is created, how a state becomes bound by a treaty, how a state may withdraw from a treaty, and relations between states parties to the treaty. So let us look at creation of treaties. So treaties are based on consent, and consent is derived from the principle that one of the fundamental rights of a state is that of sovereignty, and that is exclusive control over its internal affairs. So it follows therefore that a state's sovereignty cannot be restricted by way of treaty unless that state consents or agrees to be bound by the treaty. And that is from the Articles 11 and 13 of Vienna Convention on Law of Treaties. So let us look at adoption in the concept of treaty creation. So this is the formal act by which the form and content of a proposed treaty are established. As a general rule, the adoption of the text of a treaty takes place through the expression of the consent of states taking part in the treaty making process. So, treaties that are negotiated within an international organization will usually be adopted by a resolution of a representative organ of the organization whose membership corresponds to the potential participation in the treaty in question. So also let us look at definitive signature. So when the treaty is not subject to ratification, acceptance or approval, definitive signature establishes the consent of the state to be bound by the treaty. So most bilateral treaties dealing with routine matters of low political importance are brought into force by definitive signature without recourse to ratification. So still let us continue with signature subject to ratification, acceptance or approval. So where a signature is subject to ratification, acceptance or approval, such signature is not enough to establish the consent to be bound. So it is merely means of authentication, as well as means by which a state expresses its willingness to continue taking part in the treaty making process. And the signature enables the state to proceed to ratification, acceptance, or approval. So let us look at signature at referendum. So a representative of a state may sign a treaty at referendum that is on condition that the signature is confirmed by his or her state. So in this case, the signature becomes a definitive, that is expressive of consent to be bound if it is confirmed by the responsible organ of the state confirmed. For example, the Parliament, Ministry of Foreign Affairs. So let us briefly look at ratification. So this is the international act by which a state indicates its consent to be bound by a treaty if the drafters of the treaty intended that consent be shown by such an act. So in this case of bilateral treaties, ratification is usually accomplished by exchanging the requisite instruments, while in the case of multilateral treaties, the usual procedure is for the uh, depository to collect the ratifications of all states while keeping all parties informed of the situation. So let us look at acceptance and approval. So the instruments of acceptance or approval of a treaty have the same legal effects as ratification and consequently express the consent of a state to be bound by a treaty. But the difference between ratification on one hand and acceptance or approval on the other hand is usually a technicality based on constitutional law. So oftentimes, the constitution of a country will have elaborate provisions regarding who may ratify on behalf of the state, for example, the head of the state, as a result of which no other organ or official may ratify. So let us look at accession. So this is an act by which a state accepts the offer or the opportunity to become party to a treaty that has been already uh, negotiated and signed by other states. So, in other words, an acceding state is one which was not involved in the treaty making process but which nevertheless desires to become a party to the treaty. So, accession usually but not always occurs after the treaty has entered into force. So also let us look at the exchange of letters or notes. So in this case, states may express their consent to be bound by an exchange of letters or notes. So in this case, every state signs on a number of copies of the treaty that is equivalent to the number of signing states and then gives a copy of the signed text to each of the signatories. So in this case, the exchange of letters or notes is the final spell in the ratification process. So also, lastly, let us look at authentication, though there are other very many steps that are undertaken when they are creating treaties, but these are the few that we have looked at. So lastly, let us look at authentication. So this refers to the procedure whereby the text of the treaty is established as authentic and as true a copy of an adopted text and definitive or the final copy. So once a treaty has been authenticated, states cannot unilaterally change its provisions. So that is one of the last steps in creating of the treaties. So I have attached the reading materials for this chapter. In case you want to make further research or further reading, you can go ahead and use these materials. That's all for now. Thank you.